I have talked about the dangers of qualified immunity on this channel, especially when it comes to police officers getting away with blatant disregard for citizens' rights. Now, in a throwback to a case that I covered back in 2021, a Connecticut police officer harassed, detained, stole heart medication, and illegally searched a legal gun owner for basically no reason, even accusing him of handing over a fake gun license and dealing drugs. Now, after 2 years, the courts have ruled that the case against the cop can move forward and that he will not be protected by qualified immunity. Hello everyone, and welcome back to the channel with a huge update to a story that I covered back in 2021 that could have huge implications when it comes to not just gun rights, but also Fourth Amendment rights. Before I do that, full disclaimer, I had oral surgery last week and I still have stitches in my mouth, so I realize that I might sound kind of weird here. Bear with me. Now, I will link my original video on this case down in the description, but the short version is this. One night in November of 2028, Basil Sukane, who I'm going to call Mr. S for now because not only am I not sure how to pronounce it, but again, this does not feel great and his name kind of hurts to say, so sorry. So, Mr. S was driving around the ever crime-ridden Waterbury, Connecticut in a Kia Sorento, which is of course a super-duper gangmobile and not at all a soccer mom car. Unfortunately for him, his GPS stopped working in an area known especially for drugs and ladies of the night. He pulled over to fix it and threw his overhead light on. Now we have Officer David this doesn't feel great either, Andrzejewski, who will be Officer A for the earlier mentioned reasons. He comes a knocking on Mr. S's door, who says, "Hello, officer," and hands over his driver's license and his gun license. The cop then got handsy, dragged Mr. S out of the car, throwing him down, handcuffing him, accusing him of trafficking pills, which were actually nitroglycerin for his heart condition, and demanding to know where he was stashing the hooker that he was apparently planning to buy with the total $300 in his wallet, according to the cop. The cop threw Mr. S on the floor of the police car, ran the permit, and then apparently realizing he'd done f***ed up, called for backup, which came in the form of 7 officers detaining Mr. S for half an hour. This is the second video that I have recorded tonight and the most talking I have done in a week. So again, bear with me guys. The sergeant shows up. They share a laugh and then sit there trying to come up with what they're going to charge this guy with to excuse Officer A's tyrant behavior. In the end, they came up with a simple traffic citation, but kept his money and personal possessions because road pirates gonna road pirate? I know, I have law enforcement that watches this. I have people in the comments that will be supporting law enforcement, but that doesn't mean that civil asset forfeiture doesn't exist. It is a fact of life, my friends, and very unconstitutional. Now, this is all according to official court documents because the gun owner filed suit. The cop claimed probable cause, being that the man was a gun owner and therefore likely had a gun, and his belief that the gun permit was fake. But he didn't search the car until after learning the gun license was, in fact, legit. The cop also claimed qualified immunity, so Mr. S asked for summary judgment. The district court judge agreed the stop in and of itself was reasonable, but the actions afterward weren't, saying the cop did not have probable cause. The judge also stripped him of qualified immunity in the case. The cop filed an appeal, which is why we are talking about this again 3 years later, because that is how long it done took. Now, before I get to the new update, this video is brought to you with the help of attorneys on retainer, the lawyers that you want in your corner if you ever find yourself in a self-defense incident. The Attorneys on Retainer program from the Attorneys for Freedom wants to make sure that you are covered for legal defense if a self-defense incident happens. They are actual lawyers whose job it is to give you legal counsel, rather than an insurance company with all kinds of exclusions and fine print focused on covering their butts. Attorneys on Retainer has you covered for misdemeanors, felonies, appeals, and even bail bonds, no matter the situation and no matter the details, so long as you reasonably acted in good faith and the incident happened after purchasing coverage. So again, these guys are actual lawyers sitting in the wings for your defense, not an insurance company focused, again, on protecting their own liability. So switch over from your existing self-defense coverage, head on over to my link down in the description and use code LibertyDoll to get $50 off your individual sign-up. Now back to this story. So Officer A brings his appeal to the Second Circuit asking to reverse the district court's decision. Defendant Nicholas Officer A, an officer of the Waterbury, Connecticut Police Department, appeals from the judgment of the United States District Court for the District of Connecticut, denying in part his motion for summary judgment on the grounds that his purported conduct was not shielded by qualified immunity. That conduct, as alleged by plaintiff appellee Mr. S, is at the course of a routine traffic stop. Officer A unlawfully and violently handcuffed and detained Mr. S in the back of a police vehicle for over half an hour and conducted a warrantless search of Mr. S's vehicle after Mr. S presented a facially valid firearms permit and disclosed that he possessed a firearm pursuant to the permit. On appeal, Officer A argues we should reverse the district court's denial of qualified immunity because the presence of the lawfully owned firearm in the vehicle gave him the requisite probable cause to detain Mr. S, search the interior of his car, and search his trunk. On appeal, Officer A argues that the district court erred by denying his motion for summary judgment as to his handcuffed detention of Mr. S in the police car, search of the interior of his car, and search of the trunk of his car because he acted reasonably within the ambit of the Fourth Amendment. The order reads, to determine whether Officer A is entitled to qualified immunity for those actions, we must consider whether he violated Mr. S's constitutional rights against unlawful search and seizure, and if so, whether the violated rights were clearly established at that time. Oral arguments went down in October 2022. The cop's lawyers admitted that he went way beyond a typical Terry stop, allowing for a pat-down, but said that he had qualified immunity, again, because the gun permit gave him probable cause to search the car, including the trunk. They also tried to argue that handcuffing Mr. S and throwing him in a cop car for half an hour was not a de facto arrest. Essentially, he and his lawyers claimed that if a citizen chooses to exercise their Second Amendment rights, then they are forfeiting their Fourth Amendment rights. Which is not how it works. Fast forward to August 12th this year, and we finally have a decision. The three-judge panel again rejected Officer A's arguments and kicked it back to the lower court for further action. This is what they said. The present case satisfies nearly all of the de facto arrest factors, the judges wrote. First, Officer A left Mr. S detained in the police cruiser for approximately 30 minutes after the search of the car had concluded. The record is unclear about the sequence of Officer A's actions and exactly how long Mr. S was detained, but it is a reasonable inference based on the record that Mr. S remained detained for longer than the time it took Officer A to address any traffic violation that warranted the stop, attend to related safety concerns, or even confirm the validity of the firearms permit if he had reason to question its validity. The desire to confirm the legitimacy of the facially valid firearms permit that Mr. S presented did not, with nothing more, provide Officer A with probable cause for the half-hour or longer handcuffed detention that occurred. The judges wrote, it is uncontested that Mr. S presented Officer A with a gun license, the legitimacy of which Mr. A himself admits he had no reason to question. Moreover, Officer A concedes that he was informed of the facially valid license before Mr. S told him that he had a gun and specified its location. Officer A does not allege that the permit appeared abnormal in any fashion or that Mr. S engaged in any suspicious or threatening behavior. On the facts before us, Officer A does not provide an articulable reason why he or any other reasonable officer could conclude that there was probable cause to believe that Mr. S possessed his firearm unlawfully in violation of Section 2938A. To find otherwise would consign those validly carrying firearms pursuant to a license to automatic detention because it would effectively presume that gun permits are invalid until proven valid, or that lawfully owned guns are per se contraband until proven otherwise. Such a finding would effectively render armed individuals' Fourth Amendment rights meaningless when they are lawfully carrying firearms, full stop. Thank you, judges. In a way, this ruling is a surprising one, as this is the same court that originally upheld New York's May issue scheme before Bruin came a-knockin'. Nonetheless, it is a welcome and very logical ruling. I'm even more surprised as the decision was unanimous, even with the panel consisting of 2 Biden appointees and 1 Obama appointee. I mean, really, color me surprised. Now, Officer A could still appeal again for an en banc panel or to go to SCOTUS, but with the 2 losses under his belt, he's unlikely to find any sympathy with a full panel or at the Supreme Court, especially with the argument that one right negates the other. Alright, gang, that is it for this video. I am going to keep the outro short for the sake of these very uncomfortable stitches. Actually, this was not my best decision that I've ever made, but here it is. It's done. So, you guys know the drill for the algorithm things. As always, thanks for tuning in, and happy shooting.